it Pekalinis? Am I pronouncing it correctly?
Pekalinis.
Pekalinis. Thank you, Mr. Pekalinis. Let's wait for opposing counsel. There we go. Mr. Irvin has come into the courtroom, so you may proceed with your argument and let me know if you wish to reserve some rebuttal time.
Yes, I would like to reserve 5 minutes for rebuttal, please.
Very good.
May it please the court. And again, my name is Gediminas Pekalinis, and I'm an appellant in this matter. Thank you. And I respectfully request that the court review this appeal on a de novo basis. The questions are presented here, and we are examining 3 issues raised in the initial brief. Issue number 1 is whether the lower court incorrectly denied the appellant's motion to dismiss in proper venue when there was no established debtor and creditor relationship. The agreement was silent as to place of payment, and the debt, if any, was unliquidated. Issue number 2 is whether the trial court improperly determined that the venue for this matter lies in Hillsborough County because the plaintiff failed to carry its burden with competent substantial evidence. And issue number 3 is whether the trial court made a fundamental error and violated appellant's due process rights when canceling the motion to dismiss improper venue hearing and ruled on the motion without giving a reasonable opportunity to be heard. I have presented numerous Florida case laws in this appeal matter, and I believe this appeal has a good legal basis. To support my legal position, I provided as many case laws as I could discover, and I would like to bring this honorable court's attention to a few categories of the legal arguments that I provided, which in my opinion group the case laws by topic. Number 1, attorney fees are not liquidated damages. Number 2, the place of payment rule is not applicable. And number 3, when there is no liquidated debt, the court looks at the allegations in the complaint to determine where the cause of action accrued and where the venue lies. Number 4, once the authorized affidavit to rebut the appellee's venue selection was presented, the burden then switched to appellee. And number 5 is due process. Number 1, attorney fees are not liquidated damages. In this situation and under the circumstances, we are not dealing with a liquidated amount. Attorney fees are not considered liquidated damages, as cited in McDonald and Bowman, B-O-W-M-A-N.
Mr. Pekalinis, let me ask you a question, because I think the cases that you have referred to deal with a request for attorney's fees as an award against a party. This case, and I understand your argument, you're saying, well, they're claiming attorney's fees, but what they're, as I read the case, what they are claiming are damages for breach of contract, which happen to be for services rendered, and those services are attorney effort. So I'm not certain the cases that you have cited actually are supportive of the argument that you're making that this is not a liquidated sum.
And I have 2 more cases. Parker 1445 Wash LTD case laws. So I have 2 more, and if there are an attorney fee suit, it is a long-standing legal principle that it is a trial question that requires an evidentiary hearing with a testimony from both the attorney who performed the services and as well as an expert to determine a reasonable amount. And I would like to refer the court to several authorities. Snow versus Harlan Bakeries Incorporated, where it says that such a requirement exists because attorneys have an ethical duty to charge fair and reasonable fees regardless of the terms of the fee agreement. What this complaint alleges, the complaint, as you can see in appendix number 1, specifically claims that the appellant has unsettled debt to appellee in the amount of $97,668 plus interest and pre-judgment and post-judgment interest. The complaint further alleges that this is an action for damages based upon an open account. In a legal term, based on U.S. Legal Dictionary that I checked, open account means only an account in which the balance has not been determined. I would like to add that the bill was objected. The amount is speculative. Sorry about my Lithuanian accent. And in case law, Hartford Fire Insurance, CO versus Control Tech Incorporated, the court rejected the assertion that damages were liquidated simply because a fixed sum was demanded by the complaint. Please refer to RJG Environmental Inc. versus State Farm Insurance, as well as another case law, Koslow versus Sanders, and another case law, Department of Transportation versus Cone, C-O-N-E, and Graham Incorporated. And damages are considered unliquidated when there is no sum certain as to the damages, and evidence and accounting must be presented to determine the exact debt that is owed. The complaint is also not sworn, and the billing is not authorized, and it's not notarized. And now we may move to the place of payment, a rule known as the Crocker Rule from 1934. So my second legal argument in this is that the place of payment rule does not apply because it only applies where the damages sought are liquidated. In this case, the appellee, Mr. Denman, seeks unliquidated amount, which eliminates application of this rule. Patterson versus Teague, T-E-A-G-U-E, Finn Group Incorporated from 2nd DCA 2014. This 2nd DCA ruling in the case supports my legal argument. In this decision, the court, as well as I, in my briefs, referred to Koslow versus Sanders from Florida District Court of Appeals 2009. And it says, holding that where there is no liquidated debt involved, the place of payment venue rules do not apply, and the court must look to the allegations of the complaint to determine where the cause of action accrued and where the venue lies. Although appellee Mr. Denman claims in his answer brief that he's seeking liquidated damages because the damages can be calculated using simple arithmetic methods, this is fundamentally wrong legal application. Moreover, this so-called invoice is actually an attorney log sheet that has not been verified, was not notarized, nor authorized or witnessed. And my third legal argument is when there is no liquidated debt, the court looks at the allegations in the complaint to determine where the cause of action accrued and where the venue lies. There are 4 asserted causes of action in this case: breach of contract, open account, unjust enrichment, and fraud. All of this provides no proper basis for venue in Hillsborough County. In terms of breach of contract, I want to point out that the engagement letter makes no provision for a venue. According to the case law, sometimes where damages sought are not liquidated, the courts look to performance occurred. American International Food Corp versus Lesko, same is in Department of Transportation versus Cone, C-O-N-E, and Graham Incorporated. The judgment of the trial court was reversed, and the matter was remanded with directions that the trial court transfer the venue to the county where the performance occurred. If the claim is for failure to perform under a contract and the performance was to take place elsewhere, the place of payment rule does not apply. And Your Honor, my 4th argument is the authorized affidavit to rebut the appellee's venue selection was presented. The burden then switched to the appellee, Mr. Denman. Please refer to Rochta, V-R-C-O-C-H-O-T-A, Corp versus Kelly, AM, Insurance Corp versus Gohagan, G-O-H-E-A-G-A-N. Please also refer to Residential Mortgage Incorporated versus Kiesling. Florida case law in such situation is clear that once a defendant challenges venue with an affidavit controverting the plaintiff's venue selection, the burden is on the plaintiff to prove that the selection of venue is proper. Please refer to Tooley versus Tooley and Sunco's Home Improvements Incorporated versus Robbie Chow. Appellee Mr. Denman did not file any response. Trial court must resolve any factual disputes and then determine whether the venue selection is legally supportable. So please refer to Price Waterhouse Coopers LLP versus Cedar CEDAR Resources Incorporated from 2nd DCA 1999. And please also refer to RJG Environmental Incorporation versus State Farm from Florida 2nd DC 2011. And questions of facts such as venue must be resolved with an evidentiary hearing, please. Please refer to Leatherwood versus Card Service International from Florida District Court of Appeals 2004. Now we'll move on to the last argument in which I will argue for violations of due process. In this case, Honorable Judge Huey erred when issuing an order denying appellant's motion to dismiss 2 business days before the scheduled evidentiary hearing was canceled and violated Florida Statute 61.511 in parentheses 2, fundamental rights, procedural due process. Please refer to Sims versus Holloway, Florida District Court of Appeals 2013. The trial court decision was reversed because Sims was deprived of due process of law when the trial court entered the order without affording Sims the opportunity to be heard on the motion to change venue. Under the constitutional guarantee of the due process of the 14th Amendment, the right to be heard includes the right to introduce evidence at a meaningful time in a meaningful manner. Appellant was prevented from this opportunity. The violation of litigants' due process rights requires reversal. And my conclusion is that the trial court abused its discretion and erred in denying the motion to dismiss improper venue pursuant to section 47.122, Florida statute 47.011, Florida statute 61.511 in parentheses 2, fundamental rights and procedural due process. Therefore, I'm asking honorably that the trial court's order on appellant's motion to dismiss improper venue be overturned with instructions to grant appellant's motion and to grant such and any other relief as may be appropriate under the circumstances. Thank you very much.
Very good. Thank you. And I will give you your 5 minutes for rebuttal after we hear from Mr. Irvin. Mr. Irvin, you may proceed.
Thank you. Thank you.
My client is Blakely, Babel, Dimon, and Grace. I'm going to refer to them as BBDG in my response. Your Honor, you alluded to a very important distinction in the case law cited by the appellant, and that is we're not seeking an unspecified amount of damages. We're seeking an amount of damages for services rendered. And contrary to defendant's argument, this suit is for a collection of debt, not for a breach of services rendered. And the promise and the retainer agreement sued upon is for the promise payment of money. In fact, the only duty that appellant allegedly breached is for non-payment of money. The complaint alleges that BBDG's principal place of business is Hillsborough County. The complaint also alleges that venue is proper in Hillsborough County, Florida, because payment for legal services described therein was to occur at BBDG. That's that paragraph 3 of the complaint. The complaint seeks damages in the amount of $97,668.15 and outstanding costs of $690. The complaint also seeks attorney's fees and interest. However, as we pointed out in the brief, attorney's fees are litigation costs, and I believe the appellant also recognized that as well, as he cited to the Higley case. And the case that we cited to for the proposition that attorney's fees are litigation costs is Bidden versus Department of Professional Regulation, Florida Real Estate Commission, 596 Southern 2nd, 450. That's a Florida Supreme Court case where it says, in general, actual or compensatory damages are not identified as including attorney's fees, except when pled as special damages. And what this case really comes down to is the difference between a breach of duty to perform versus a breach of duty to pay the amounts due. If the court finds that this case is for the latter, the duty to pay the amounts due, then venue is proper in Hillsborough County because payment was due at the BBDG in Hillsborough County. There is no other offices in Florida. The only office is in Hillsborough County. Now, the appellant cites to Coslow versus Sanders for Southern 3rd 37, where it says the court found the only duty Coslow had under the parties' agreement was to handle all administrative forms and related details for sales made by Sanders and his representatives at no charge to Sanders. The complaint generally alleged that Coslow breached its duty. That is a duty to perform services under the agreement. The allegations were therefore considered a breach of performance and not for breach of payments for monies owed. Here, the only duty that appellant had was to make payment. That duty was breached. The cause of action accrued in Hillsborough County, and that's where payments was to occur. Even if the court finds that the payment venue rule does not apply, the result is still the same. Because if the rule does not apply, as appellant correctly pointed out, the court must look at the allegations in the complaint, determine where venue lies. And both appellee and appellant cited Morales Sand and Soil LLC versus Kendall Properties and Investment. That's 923 Southern 2nd, 1229, where the 4th DCA says that you got to look at the complaint and determine where venue lies. And when you look at the complaint, it's clear that at paragraph 5, it says that venue is proper in Hillsborough County. So the right to initially select venues belongs to the plaintiff. That's Gulfstream Seafood, 830 Southern 2nd, 908. That's a Florida 2nd DCA case. For the plaintiff's venue selection is presumptively correct. It's the defendant's burden, and this is contrary to what appellant pointed out earlier, is that the defendant's burden to plead and prove that venue is proper. In doing so, the defendant must provide a sufficient basis to overcome plaintiff's presumptually correct venue selection. Merely establishing that venue is proper elsewhere is not enough. Rather, the defendant has a burden to clearly prove that the venue selected by the plaintiff is proper. And it's only when the defendant provides sufficient factual basis does the burden switch back to the plaintiff to prove that its initial venue selection is correct. So it's our position that the defendant never presented adequate or sufficient factual basis establishing that venue was proper somewhere else. In his affidavit, he says that he made payment from Pinellas County, but he never says where he made payment to. That's because payment can only be made in one place. That's in Hillsborough County, where BBDG is located. So the issue is very simple, and it's our position is very simple. If the court finds that the duty to pay the amount due is what is sued upon here, then the payment venue rule applies, and it is applied that the venue is proper in Hillsborough County. And even if it doesn't apply, then if the court looks at the allegations of the complaint, it's clear that venue is properly alleged in Hillsborough County. Now, as to appellant's argument that he wasn't afforded due process when Judge Huey summarily denied his motion without a hearing, if you look at the cases cited in the answer brief, it's clear that not all situations require a hearing, and especially here when the burden has not been met. That is, he has not provided a legally supportive basis to establish venue other than where we pled in our complaint, then the burden never switched. If the burden never switched, then the motion can be dismissed by the lower court. So we believe that Judge Huey's ruling was correct. We would ask the court to affirm. Thank you.
Thank you, Mr. Irvin. Mr. Pakalinas, you have your 5 minutes for rebuttal. Don't forget to take off your mute.
Yes, Your Honor. It is not true regarding a non-payment. I paid over, I spent over $61,000 for approximately 5 months to Attorney Denman and his experts transcript. Over $61,000 approximately 5 months. And so I added that in my affidavit, that information. And I would like to know that in my reply brief, I said and I showed bank statements and record that I was to send the money first payment to Alabama, Dothan, Alabama. So there is evidence exhibit in my reply brief which shows that the money went to Alabama. And again, again, appellee did not present my evidence against billing, and billing was objected, as I said in my affidavit, as well as we can see in the appendix for initial brief. Moreover, as we have related case, Denman versus the state of Genita Dirse, Mr. Denman sues them for the same amount and billing. And I think I'm confident we have here clear due process violations. So the attorney log sheet is not liquidated, and it's not authorized, and it's not notarized. So the attorney sheet is not legitimate, in my opinion. I would like to refer, Your Honor, to case law, Abdul Hassan case, where the law firm sued its client. Client was appellant, and matter was granted in favor of the appellant, transferring matter in his client's favor to his residence, and where the attorney services were received. Here in this case, we also had a law firm suing the client. Attorney's fees in the second DCA case was considered not liquidated, and this is very similar lawsuit to the one that we are in today. There is no liquidated debt, and appellee did not provide any proof of evidence. The complaint is unsworn, and the billing requires evidentiary hearing. Please, it is allegation for non-payment is just allegation. As I presented the evidence with my payments and my receipts, I paid over $61,000 for approximately 5 months, as well as I presented that I was advised not to pay in full. The bill was objected, and it's not reasonable. We have appellee suing the state of Genita Dirse, relating the case for the same attorney work performed. If you look at the billing attached to the complaint, it says guardianship of Genita Dirse. It is, Your Honor, accounting is necessary, please. And as I said in previously, the amount is not liquidated. Please refer to that Abdul Hassan case where we also have law firm sued the client, and clearly, Honorable Judge Huey violated due process. So this is, I think that's all I have to say. Sorry, trying to get organized.
Well, you're fine, Mr. Pakalinas. You have about 30 seconds left.
Okay. Honorable Judge Huey canceled the hearing and not allowed to have an evidentiary hearing where I was able to submit evidence, records, and important evidence. And this right was violated. I didn't have a chance to submit important evidence that I had. It was like hours, 2 business days, the hearing was canceled. And I put that information in my affidavit. I put all that information in my affidavit. Thank you, Your Honor.
That brings us to the end of the time, Mr. Pekalinas. I will compliment you as a pro se litigant. The cases and the briefing that you provided were very helpful. And Mr. Irvin, of course, yours as well. Thank you both, and you may exit the courtroom. The next case is Parisi versus Caviola.
Thank you, Your Honor.